Good afternoon, everyone. I'm Jaqueline Julyan. I'm from 5 St Andrews Hill. I'm head of the International Family Law team there. You will hear two things from my voice. One, I have a horrible cold, and forgive me. It's a result of being in Birmingham all week. Number two, I'm from South Africa. I studied both in South Africa and in England. I'm dual qualified. I was called to the bar first in South Africa, then called to the bar in England, and I continue to maintain a dual practice. It's not usual, but I commute between South Africa and England like, as one of my friends said, she used to think her London Farnham commute was long, and then she met me. So I'm in Silk in South Africa, SC. I don't have QC behind my name, I have SC behind my name, but so I'm going to talk to you from having been at the bar longer than I care to tell you, because if I tell you my sell-by date, you're all going to look at me and think she's about to crumble into dust before us.
I'm Tom Dance. I'm at 1 Kingsbench Walk, a specialist family set. I know I've spoken to some of you today upstairs. We do a full breadth of family law in 1 KBW. I came, I suppose, a relatively standard route and quite quickly to the bar. And I did an undergraduate degree in law and then a master's, and then came to do pupillage at 1 KBW. So it was relatively quick. I don't have a South Africa practice, sadly. I'd love it if my life was that interesting, but actually I spend most of my time going to Barnet County Court rather than South Africa.
I'm Sara Granshaw. I'm at Harcourt Chambers. Harcourt Chambers does, again, a wide breadth of family law, international, money, children, a lot of child protection work, a real mix. And I've been at Harcourt Chambers from the very beginning. I did a year's pupillage there, was called in 1991, and my pupillage was in the days when you did 12 months with one pupil master or pupil mistress. So times have changed since then. I'm chair of the Pupillage Committee at Harcourt Chambers, and I think I've spoken to some of you again this morning. We're here really to address different topics between us and try and address questions that are commonly asked of us.
And showing a lack of preparation on my part, I forgot to tell you what 5 St Andrews Hill does. The family team does just as 1 KBW does, and Harcourt Chambers, a broad spectrum of family work. We don't specialise in any particular area. We do all aspects of family work. I'm head of the team, and I'm the immediate past chair of the International Bar Association's Family Law Committee. So obviously there's a huge international slant to our work, but that's purely coincidental. That's not because we focus on it. It's just because a lot of international work comes into our chambers. Right, I'm going to talk to you on the kind of cases that you can expect to do. 2 weeks ago, I got a phone call from a solicitor. She has a client, a mother, who's just seen the dad, who had the 2 children for midweek contact and was having them stay overnight, had checked in on Facebook at Gatwick Airport, which understandably gave her cause for concern because she thought he was taking them to the local McDonald's for dinner, not to Gatwick Airport for dinner. Quick telephone application, and we managed to get the tip staff to Gatwick Airport in time to literally take Dad and the 2 kids off the plane that they were about to fly on to Dubai, and from Dubai, who knows where. That's the really exciting kind of dramatic thing when you're working to real deadlines and will the tip staff get there in time. It doesn't happen every day, but it is what gives you that real adrenaline rush about family law. A less dramatic sort of, that's international child abduction. A less dramatic form of international child abduction is one I'm doing right now, where an American father married to a South African mother living in America, child born in America, and the mother wanted to go back to her family in South Africa, in Cape Town. She's there as we speak. She was supposed to leave on Friday because his consent to the child being removed from America was to end on Friday. She was supposed to get on a plane on Friday. On Friday, she did not get on a plane. We're talking not yesterday, but Friday the week before. She did not get on a plane, and she said to him, the marriage is over, I'm not coming back, and you can see your daughter 10 times a year because your contribution to the child has been 5%, and that equals 10 days a year. So now we're in proceedings in terms of the Hague Convention on International Child Abduction to try and get the child back. Now that's also an abduction. Although she took the child out lawfully, she's retained the child in South Africa wrongfully because the date has expired. Then on the flip side of child abduction, you'll get child relocation, not where the parent wrongfully takes the child away, but where the parent wants to ask the court for permission to take the child away because the other parent won't consent. So, for example, a couple that's been divorced or separated for years, children live with mother, father has contact, everything's tickety-boo, absolutely no problem. Mother meets somebody else, she wants to get married, and he gets a job in Australia. And she would like to move from England to Australia, and of course she wants to take the children with her. Now you can imagine the impact that that is going to have on father for his contact with the children. So obviously he objects. Mother now has to come to court to ask for leave to relocate. That's one of the extremes. You can also get it in a situation where mother living in Newcastle wants to relocate to Brighton. So you'll get internal relocation, external relocation. Surrogacy, that is an absolutely fascinating field to be in because there's so many aspects to it. And it raises so many issues, not only about the legalities of surrogacy agreements, which I won't bore you with, but for example, a couple decide to go and rent a womb in Ukraine, and the child is born in Ukraine. What do you do about passports? It doesn't happen anymore because it will happen, but theoretically it doesn't because India has now banned surrogacy. But India was the surrogacy baby farm until recently. Went out to India, rent a womb very cheaply, got your baby brought back. But the trouble is the child is born in India. Now you've got to get child into England. What's the child's immigration state? You can end up with a stateless orphan. So it's a really, really fascinating field, surrogacy, but it's a field all on its own. I could spend hours talking to you about that. Then there's international adoption, local adoption, and that can be very, very rewarding when you're placing a child with a family that really wants it and can't have it. It can also be heart-wrenching when you're acting for a mother whose child is going to be put up for adoption because she's been an inadequate mother and she now wants to reform. And it's just too late for her. So you're going to find that if you do family law, you're dealing with the stuff of life. You're not dealing with goods sold and delivered and whether there's the right metallurgical content to some piece of equipment that was delivered. You're dealing with real life on a daily basis, and it's absolutely fascinating. And so you can do local adoptions, you can do international adoptions, which again is covered by the Hague Convention on international inter-country adoptions. And those can be really tricky as well, because again you have to deal not only with family issues, but with immigration issues. If you're going to go into money cases, you're going to find that you're dealing with assets, where the assets aren't just in husband's name and wife's name, but they may be in the name of a trust. It may be that the bulk of the assets are sitting in a trust. What are you going to do? So you're going to try and bust that trust, which means you've got to be able to understand financial statements. You've got to be able to understand figures. I don't see why people say it's difficult. You know, if you can add up a restaurant bill, you can do family law finance. There's no mystery to it. It's simple arithmetic. But it's fascinating stuff because, again, you have to have a breadth of knowledge because you have to know about trusts. You might have a spouse who's declared bankrupt. What's the impact of bankruptcy on the divorce order? So it's not just family law. You can't say, oh, I only do family law. You have to know about so many things from immigration to trusts via company law if you're going to do family law. Let's see if there's anything. Oh, and you may want to read Ian McEwan's novel, The Children Act, because that is written from a judge of the family court's perspective. And it's actually astonishing in its very realistic take and explanation of the kind of cases that a family law judge will see. And that will give you an idea of the kind of cases you'll do if you go into family law. And the entire conceit of Ian McEwan's book is that there's a 17-year-old child, 17 because he's nearly adult, who is a Jehovah's Witness. His parents are Jehovah's Witnesses. He needs a blood transfusion because he's got leukemia. Without the blood transfusion, he'll die, and he'll die a horrible death. His parents won't consent to the blood transfusion because their religious creed forbids it. He won't because he was brought up as a Jehovah's Witness. The hospital that wants to perform the treatment goes to court for an order permitting them to do the blood transfusion. That's the sort of overriding case of the book, but you will find, if you read it, so many examples, and it's a fascinating read. So I offer that to you. Thank you.
I'm now going to talk to you about life at the junior end of the family bar, which I'm in a good position to talk to you about, seeing as I'm only, I think, 3 or 4 years call. I gave one of these talks 2 years ago, I think, and that was also recorded, and I hadn't really realised that, but I gather that's also on YouTube. So I'm going to try not to repeat what I said that time. It's been pointed out to me many times today what I said that time. But I'm not sure my life has changed hugely in the last 2 years, save that I suppose I'm now a bit busier even. But the junior end of the family bar is as romantic as the description of these cases has just sounded. Not quite as romantic or as interesting as that, because as a junior barrister, sadly, you are not the first port of call in a very complex surrogacy case. What you might be is the first port of call in a very bog-standard but no less acrimonious children case where two parents can't even agree about whether a child should be collected on a Wednesday evening or a Thursday morning, or how the holidays should be split. And I mean, I have to say that they are in their own way as fascinating as the complicated legal arguments, even though one might say from the outside that there's not a huge amount of law involved. And the same can be said for a matrimonial finance case, of which I do a lot, where there aren't millions of pounds or assets in trusts or assets offshore, but what there is a house and a little bit of income, and that's suddenly got to be split across two families and perhaps support two children as well. And those cases are pretty heart-wrenching and pretty difficult in their own way. I find it harder to care about a case where there's 20 million quid to divide between two people than I do when there's 200,000, I suppose, on one level, because the implications for the latter parties are so huge. I live an odd sort of peripatetic life, I suppose, where I go from, I mentioned Barnet earlier, I think simply because that's in my mind, because that's where I've been this week, but I sort of trot off to relatively far-flung places, and you get into nice routines whereby every time I go to Brighton I have an ice cream at the same shop and go and sit on the beach, whether it's raining or not, under a sort of umbrella, and think, well, if I'm going to be on my own in Brighton, I might as well go and have an ice cream on the beach. It's a really weird job, in that you go to these places on your own, you've got no one sort of really supporting you, save that in its way, and in that becomes the sort of beauty of the job. I don't have to report to anyone what I've been doing. These are my cases, I work on them, you care about them, you work hard, sometimes you get a good result, sometimes you get a terrible result, and it's pretty dire. I mean, I think we can probably all agree on this table, when you've worked hard on a case and you think it's winnable and then you lose. Perhaps it's my naivety as a very junior barrister, but it hits you quite hard, but I suppose it means that you work even harder for the next one. But it's a fun job. I meant to be talking to you about the lifestyle implications. it's a sort of running joke, I suppose, amongst barristers when you talk about, you say, and it's been said in private to me at this table earlier on, I said, I'm going to talk about lifestyle implications, and it was said, what life? We don't have a life. Don't believe it when barristers say that. We love to complain. I'm sure you're all lawyers. We all complain the whole time. We complain about how hard we're working, complain about how much we don't like what we're doing. Yes, we work hard. Of course I work hard, and I work silly hours, but at the same time, it is a job that gives you flexibility that lots of other jobs don't have. Different chambers are different and different people are different, but I'll be careful what I say on film in case my clerks watch this video. But if I finish court early on a Thursday, I might take an hour off, go meet a friend for a coffee, I might go to the gym. If I'm not in court on a Friday, I'll ring the clerks up and say, I'm not going to be in court on Friday, and what I'm going to do instead is maybe to actually have a weekend for once, that type of thing. I mean, there is a freedom in this job that lots of my friends don't have, and so I will always appreciate that, and I'm very keen to take advantage of that, because when you're working hard, you're really working, because that's the implications of being on your own and having your own caseload. But if you take advantage of it, and if you enjoy the flexibility that comes with it, it's a unique job and a pretty fun job. My contemporaries who are working in the very standard professions of law, what do people do? Solicitors, banking, all this sort of stuff. They sit behind a computer screen. They might not be that busy, but they've still got to be there. They've still got to put in FaceTime. We don't have to do it. And I have a uniquely interesting job compared to pretty much all of my friends, I think. They may be very bored about hearing about it, but I'm certainly bored of hearing about their jobs. So I'm eternally grateful for it. And don't be too put off by the sort of constant, it's hard work, it's hard work, it's hard work. It is, but it's pretty cool. That's enough from me, I think.
And now your friends have heard that on YouTube. You're going to be very popular. I find it a very fulfilling job. I've been doing it obviously for quite a while. I'm as fulfilled now as I was in the very beginning. I find the variety and there's a lot of travelling with my chambers. Less so now because my clerks have been very accommodating. I have a youngish family and they've been able to accommodate me travelling less. So I've got a narrower geographical base, but I find the variety very, very interesting and stimulating. It is tiring. You have to have stamina, in my view, at the bar. Good health helps. And it's tiring because you do get days off. You can put the odd day free in your diary, and that makes it fantastically flexible. But when you do have a court case that you have lined up, there are court deadlines, there are filing deadlines. Preparation, thorough preparation, is key to the success in any case. And that can be tiring when papers come in last minute. With the best will in the world, you request them a week before, you chase them, they come in the night before. So you do have to have stamina. It can be, at times, it can mean far less sleep than you should have. That can go on for several days. Other times, as we say, you can end up with very nice breaks where you can factor in. I think it's essential, whatever leisure time you have, whatever hobbies you have, that you have hobbies where you can fit them in round your work. It is very difficult, I find, to have a social life and hobbies where I have to be somewhere at a certain time at a regular time each week, because my practice doesn't work that way. And I have cases that come in and I do have to prioritise them. So it's really important, if you have family, that you have a support structure. That can mean that you can prioritise your work at all times when you're committed to doing a case, and the case comes first. As I say, thorough preparation is key. You have to have, I think, an ability to digest quite large volumes of material at times, fairly quickly, thoroughly, retain that information, manipulate it and use it during the case, adapt your arguments to whatever crops up, and then forget it and move on to the next case. And sometimes having 2 or 3 or 4 shorter hearings in a week can be more demanding because of the amount of reading you have to do for each one than having one 5-day or 2-week case where the reading is all front-loaded and it's a lot lighter during the rest of the time. So you have to be prepared to put in the hours and to be able, as I say, to move on from one case to the next, but hence the variety. As I say, that can be very stimulating. IT skills help a lot. I came from a generation where it wasn't a requirement when I started out. It's now absolutely essential. And when we have pupils who come to us who are so IT literate and effectively type at 10 times as fast as I do, that makes them extremely effective. Not necessarily effective advocates, but effective at the bar. So I would say definitely take every opportunity to brush up on the IT skills. At the family bar, I think empathy is something that is really valuable. Across the board, whatever area you're practicing in, it can be less important in some areas of the law than others. I personally think, and I do across the board, I don't do international, but I do all other areas. At the moment, I seem predominantly to be doing child protection work, serious child protection cases, where obviously empathy is important. But even in money cases, I think it's important to have empathy. And to quote a lawyer in a novel, you have to be able to get into someone's shoes and walk around in them in order to know exactly what story they're asking you to put and what objective they want you to achieve. So for that reason, empathy, sympathy, being able to see things from other people's perspectives, regardless of your own views, you have to be able to suspend your own views and not in any way judge your client's case, but work out what their tale is, what story you are telling on their behalf, and make it a compelling one. You have to, I think, have a quality, I'm not saying I achieve these things, but you have to have a quality where you remain calm. Whatever happens, you may be paddling furiously underneath, but up above you have to be completely calm or appear completely calm. And appear to deal with whatever's thrown at you. You have to be, as a family lawyer, I think, pretty tough. Some of these qualities appear to contradict each other. Empathetic, compassionate, sympathetic, and yet tough. But a lot of the things that I'm mentioning require a certain toughness, a resistance, an ability to withstand stress and pressure, but find ways of relieving that when you get every opportunity. You do have to be flexible, I think, socially. Dinner parties with friends, etc., you arrange them. You do have to have friends who are very patient if you can't turn up. It is an unpredictable lifestyle. In terms of applications, you're I think all at the stage probably where you're either contemplating making applications this year or certainly in the next year or two. I, as chair of the Pupillage Committee, along with colleagues who sit on the Pupillage Committee, we screen many applications each year. And it stands out, I think, those applications which are likely to be more successful, whichever chambers you apply to. There are certain things that all chambers will be looking for. Firstly is accuracy on the face of the application. So making sure that you really do proofread it and it is spelling free, spelling corrections are made and it reads well. Make sure you structure your answers to the questions. Unfortunately, I think it's regrettable that the questions are so standardised. And it is very hard when you're screening applications. You obviously come to each one afresh and see each one as an individual candidate answering those questions. But they're so standardised, with the best will in the world, it is very difficult, I think, for individual candidates to stand out in a fresh way in answering those questions. That's what you need to strive to do, in my view. You need to make that interviewer, or the person who's screening your application, sit up and think, this is different to the one before. This is an individual. I want to meet them. They sound interesting. They've achieved things. And not necessarily academic. Academic at the bar tends to be a prerequisite. You do have to have a certain ability to do the things that we've described. But that aside, you need to have a personality. And that needs to come across, I think, on the face of your application. Not necessarily to get through that first objective screening process on paper, but to really stand out at interview, the next stage, if you get to that stage. So try and emphasise the things that show you as an individual, what you've achieved extracurricular, whatever it is, jobs you've done. It doesn't matter. I worked in Marks and Spencer's next. I had to earn money before I did pupillage, before I went to university. Retail. It's not seen so much on the face of the applications nowadays, but it gives you valuable customer service skills even at a young age. You're handling money. Whatever you've done across your life so far, look at whatever you've achieved and try and tie in on the face of your application the qualities you've got from it and what you've achieved from it with what you've done. And it doesn't matter what it is, but just try and put it down and make yourself individual. Be clear about the points you're making. Make every point on the face of your application relevant to the points you think they're going to be looking for. Don't be waffly, be concise, be succinct, because the people who are screening the applications will have read many. So you make your points clearly. Where you put down qualities, evidence them concisely. And you research your chambers that you're applying to so that you can show that you are, just as you're hoping they see you as an individual, you've chosen them for their individual qualities. Be really careful. I remember one interview where I sat with a member of my chambers and the candidate turned to him and said they were well aware that he did media law and television law, and they wanted to come to chambers because they had a particular interest in that, and he hadn't done a single media law case in his career. And others where they sit there thinking that you're a commercial chambers and they get as far as interview and they realise that actually you do very little commercial or whatever. So you do really need to research your chambers well. And it's very difficult because you'll be making applications across the board because you don't want to put all your eggs in one basket, and it's very difficult to know a lot about so many chambers. But do your best to know your audience. And then I think my final message on what stands out to me when people are making applications. At the moment, so many are doing so many pupillages and so much marshalling, and that's great because it shows a commitment on the face of your application to the bar, the family law bar. It shows you know what you're getting into, and if you've done many pupillages at the chambers you're applying to, it's brilliant because it shows you're interested in them. But in terms of the application, a lot of space is taken up on describing by some candidates everything they've done during each mini pupillage. And if they've done 6 or 7, that's a lot of writing. And so try and keep it down, I would say, on mini pupillages. List the ones you've done, maybe put a few key points about the areas that you did in each one so that the interviewer knows what to talk to you about, what you'll have seen. But you can, I think, work on the assumption that quite a lot of the candidates will have done quite a lot of mini pupillages, some marshalling, some pro bono work, etc. For my part, in our chambers, I would say that 2 or 3 mini pupillages that confirm for you and reinforce for you that family law bar is where you want to go is just as good as doing 6, 7 or 8 or 9 mini pupillages. Some people can't afford to do more than 2 or 3. Some people don't have the time and don't feel disadvantaged by that. So I think there's a lot of emphasis on mini pupillages and marshalling. It's good to do, I think, a week of marshalling if you can. But don't feel disadvantaged if you can't do all of that. So those are a few of the things that I would say looking out for on the face of applications. I don't know, it's very personal to each chambers, and I don't know if what I'm saying is
no,
it meets
I
with
definitely support
universal.
that, yes. And just to support that last point, I did not do 8 or 9 mini pupillages. I think I did 2. I managed to wangle a day's marshalling in the Central Family Court by sending an email to who was the clerk. I managed to get the clerk's email of the then head family judge in the CFC. He's not there anymore, but I didn't do anything more than that. I think I did a moot at university. I'm not saying this is what you should do, but there is no set route. I have co-pupils who did 10 mini pupillages and 1 mooting competitions and have been to sit with international judges, and then there's me who hasn't done any of that. So there are completely different routes in, and it's exactly what's just been said. Use your own personal experience to explain and evidence why you're suited to the job, whatever that experience is.
If I can just say, mooting I think is very valuable. So if you can't do mooting, though, if you show an aptitude for public speaking, debating, drama, anything that is in the performance field, where those interviewing you know that you can stand up in front of an audience and you're comfortable with that. And that is, if you're going to a set that does a lot of advocacy, that's really important.
Free representation unit as well.
Absolutely. Anything that gives you that experience of talking to an audience and you can say to the interviewer, because they're going to say, why advocacy? And you need to be able to answer that. So anything that requires oratory, performance, whatever it is, it's relevant to your application.